Right, back with you tonight here on In Focus. The Supreme Court of Appeal has dismissed with costs and application by the Ingonyama Trust board for leave to appeal the Pietermaritzburg High Court ruling. The High Court had declared as unlawful and unconstitutional that a trust can force people to sign leases and pay rent on tribal land. The Supreme Court of Appeal has also ordered the trust to refund those who had paid rent believed to run into millions. It also pointed out that Rural Development and Land Reform Minister had breached her duty to respect, protect and promote the constitutional rights to property of trust land residents. Joining us now to make sense of this ruling is Tshepo Fokane, researcher at Alliance for Rural Democracy. Tshepo, good evening. Good to have you with us tonight here on In Focus. You do work towards challenging undemocratic practices and discriminatory laws, particularly in rural areas. What contribution does this ruling make towards the debate about ownership and governance of land in communal areas? I mean, for example, it says the Ingonyama Trust acted unlawfully and in violation of the Constitution by leasing land to true beneficial owners of trust-held land under Zulu customary law by virtue of being members of the tribes and communities.
Good evening, and thanks for having us, and greetings to all the viewers. This is a really important judgment because this appeal, in part, I think, was brought to suggest, my apologies, that the judges in the matter were also impartial because they may have families that are living on land under the Ingonyama Trust, and that really rural people who are speaking up for their land rights are anti-traditional leaders, induna nenkosi noma isilo, whereas in fact it's exactly as you're highlighting. It is about acknowledging that customary landowners under Zulu customary law it is the equivalent of private ownership. And it's this challenge we've got in our country where about a third of our population is living in the former Bantustans, so beyond the borders of KwaZulu. This is prevalent all over, where decisions are made about people's land and they are disregarded even though they are essentially private owners. And it shows you the parallels between the life that you would experience in an urban setting versus a rural setting. There are so many assumptions that your land is a free-for-all emakai. When you drive, when you walk, when you live, when you visit your family there, people think all of these open spaces are going to use, and yet they are land uses that were negotiated and agreed by communities, by families, and especially by households to say, these will be our plow fields, this will be where we graze, this is where we hunt, this is where we perform our rituals, this is where we bury, this is where any number of land uses. So it really is an important judgment, and we are really hopeful that what is going to follow is that, in fact, all of the monies that were paid by residents will be returned to them, because it is really wild that one day somebody introduced residential leases, this being the trust, with little to no conversation with the actual landowners, to the extent that all mama were not even allowed in some of the areas to sign the lease themselves. They were told, "Hamba uyofuna indoda." So what that means is I'm living there, looking after the land, making improvements on the land. We've agreed with my family, with my household, that it's my area. And yet, when it's time to sign the lease, which is declared unlawful, I still had to go and find a man. So a judgment like this is really reinforcing what was said in the Pietermaritzburg court, which we are really excited about, which is that customary land ownership is equal to private ownership.
Yeah. The Ingonyama Trust seems to argue, for example, that the PTO was weak in law. In a sense, this change tenure arrangements was to exert, maybe would be a heavy word, but at least to enforce the traditional authority on those who reside in rural areas. What does this mean? Do traditional heads or chiefs, authority in the area now, are they rendered powerless as far as the ownership of land?
Well, it is a fact that most of our rural areas The state is the custodian through the Department of Agriculture, Land Reform and Rural Development. And our traditional leaders are actually there to administer the land. So when it comes to decisions of allocations of, let's say, a residential site, I don't see any reason that a judgment like this would render any traditional authority redundant, because in actual fact, that is the challenge of communal tenure, that we don't have a permanent piece of legislation that is going to enforce and protect the rights of abahlali, no matter which province you are in. We are still relying on IPILRA, the Interim Protection of Informal Land Rights Act, which outlines really in detail, and the judgment, I think, in Pietermaritzburg really went into depth about how you would dispose of people's land rights, making sure that people are consulted, that they consent, and making sure that we use IPILRA in all of our dealings in communal areas. So this judgment, to me, poses no threat, because nakhona, what do we think as a country is the role of a traditional authority? Do we think it's their role to own land? Because they're not the owners. In actual fact, we are the owners. We own the land. Of course, it's registered in the names probably of our national government or our provincial governments, because that's a Bantustan era legacy, where the former homelands, when they were collapsed, would have found that those pieces and parcels of land would now be owned by, our government, local, provincial, national. But it is never supposed to be that a traditional authority owns the land where you live, and that they would be making decisions and making you enter into a lease. And what's also really important is that this is a conversation about residential leases. The commercial leases will still be in force, because people who want to oppose commercial leases will have to do their own process of saying they found fault with some of the commercial leases. Yeah. But that's not what this work is about. And it's not also about the other categories of leases, whereby, let's say, your churches, your creches. This is specific about where you live, where you own land, where you are the decision makers as a household, as a family, as an individual, and how the leases were imposed on you, and how that money is to now be restored to you. And people should also get public information and education to say, stop paying your leases. We're not sure how many people are aware. There's been very little public education, as I understand it, coming either from the state or even from the trust to say, this is what the judgment said in Pietermaritzburg, and even from now, with the SCA. So it's really important that we don't conflate and think we are now saying that, Amabuno, white commercial interests are winners. Because I've seen this rhetoric on social media, and I think it's being fanned by some people who would like to paint individual rights holders, customary landowners, as being opposed, anti-chiefs, anti-development. That's not the case. People were speaking up and saying, how fair is it that one day somebody comes and tells you you no longer own, you are a tenant?
Politicians giving concession to traditional authority, of course, is another issue that is being raised here, including the role of the Department and Rural Development in terms of their control and usage of land in rural areas. 27 years later, still no legislation. I mean, you've already spoken about it. This is not just about KwaZulu-Natal, but it is about communal areas nationally. What does this mean then in terms of going forward, and what politicians would need to do?
So this is really interesting, because last week we had a land conference with a mix of activists and academics from all over the world and attorneys, and we were trying to put our heads together around, the failed promise of secure tenure in communal areas. And the fact is, what's on the table now is a communal land tenure bill. It does not speak in the same way as the IPILRA around recognizing your rights, right down to individual, household, family level. It, in fact, would give more powers and decision-making authority to traditional leaders around not just governance of land, but, administration. And when you read that and you know also that we've now signed into law the Traditional and Khoisan Leadership Act, which specifically in Section 24, the Traditional Khoisan Leadership Act now enables the traditional authority to enter into a deal or negotiation with a third party. This could be anyone, private interests, municipalities. So when you think about allowing power to be centered and decision-making to be centralized in an individual or an institution that may not be fully democratic, may not consider the needs of women, individual households, vulnerable populations, you see the challenge here. And like you're saying, this is countrywide. We are really, really worried that lawmakers and policymakers are repeating the same mistakes. The high-level panel report, chaired by then President Motlanthe, and it's really Parliament's panel, put out some really interesting recommendations around saying the way that the trust has functioned needs to be reviewed. But moreover, we need to really recognize that individual tenure has to be promoted and protected in line with the Constitution and the right to property. And so all of this comes together. It's not this one isolated event where you see residential leases in one province, because if it were not challenged by people living on the land with KSAG and a powerful movement such as the Rural Women's Movement under the late Mamsizani Ngubane, then what would happen is in other provinces, we'd hear as well, Harafika Northwest or Free State, that they've now introduced residential leases because it's the status quo. So that's why we speak up. That's what we're trying to promote and defend and protect against, is this overreaching power that is now seemingly being passed off to traditional authorities, right. And our government departments are taking a back seat and seemingly opting just to, wait and see, or pit us as people against traditional leaders. And that was never what I thought the Constitution had in mind for us. Traditional leaders are the custodians of customs, practices, right. And that should be, remembered.
Yeah. Tshepo, appreciate your time. Thanks so much for coming on and joining us this evening. That is Tshepo Fokane, the researcher at the Alliance for Rural Democracy.